Can you please give some background to the mandatory pre-deposit condition?
See, when this mandatory pre-deposit condition was imposed, the objective was that these stay applications which are before the court are expedited. So, in a way, the mandatory pre-deposit would not get then into the situation where the petitioners or the taxpayers are getting into an additional layer of litigation for arguing these matters. But what happened after this pre-deposit is that lot of these cases where the demands are not genuine and are frivolous will have to bear the brunt of this 10% tax, which was a big hardship in various such cases.
Enlighten us on how it helps the taxpayers.
See, this decision of the Bombay High Court, if you see, it really helps the taxpayers in those situations wherein there are genuine cases of these demands and which the taxpayers feel could be dropped on merits. Now, what will happen is when these matters are now taken to the appellate forum, be the tribunal or the appellate forum for stay application for addressing on the stay, the taxpayers may get the stay for not making any payment or making a payment perhaps less than 10%.
Do you see any further litigation?
Of course, there can be litigation in a stage where even the adjudicating authority or the appellate authority today feels that the amount has to be more than 10%. So now if the matter is before the tribunal, but the tribunal feels that the stay has to be given but only on a payment of 50%, the matters will go to the court. So there will be cases where there may be litigation which may happen, and there could be cases where the taxpayers will be at a big advantage. What the court has done very categorically in Bombay High Court of our cases, when we argued, interestingly the court said that even if you have not filed an appeal, you have the right today to file an appeal. You can file the condonation of delay application as well, and on the pre-deposit amount, the adjudicating authority or the appellate authority will decide the case on merits.
Questions under the GST regime.
Interestingly, even under the GST regime, there is a provision of pre-deposit. The issue before the Bombay High Court and the VAT authorities was slightly different. When this amendment came in 2017, at that point of time, there was no pre-deposit condition. The matter went to the court, and in Anshul Impacts, we got the favorable order. Thereafter, 2019 ordinance was passed, which was again challenged, and then the matter went to the Supreme Court. When we went to the Supreme Court today, then there was a favorable order which came. And now, as we speak, today we have the order of this Bombay High Court, which will have huge implications, at least for the VAT regime and the earlier regime. But what will happen is that as far as your question of having the implications under the GST regime is concerned, there will be some precedence value which it will have even under the GST regime. And that is for a reason that there could be situations even under the GST regime where this pre-deposit is a burden. And when this pre-deposit is a burden, the genuine taxpayers have the constitutional and the statutory right to file an appeal. And in genuine cases of difficulty, there may be a situation when the petitioners are going to the court for waiver of this mandatory pre-deposit condition. And under GST, it could be as high as 30% if there are two stages of litigation, and it could be a serious problem. The writ court will certainly be the forum to test the constitutional validity of such hardship if this is a genuine hardship, as it curtails my right to file a statutory appeal and debars me from the constitutional benefits which I have.